Hello friends, we are back after a long time. This is Advocate Mahesh Mandhana from Swatantra Legal Advocates. Today we are going to discuss the meaning of the term service in the context of GST law, and our focus will be on the assignment of leasehold rights in immovable property or in land and building. Friends, first of all we will see what is service. Whenever an agreement is entered into between two persons for providing service, the main purpose of the customer is to take the benefit or to obtain the benefit, which may be of a permanent nature or a temporary nature, benefit of the skills, the knowledge, the manpower, the resources or assets of the service provider. So the purpose of the service recipient is to obtain a temporary or permanent benefit from the skill, knowledge, manpower, or tangible or intangible assets of the service provider. Generally, in case of contract of services, the main purpose is never to get the ownership or the complete ownership of the any resources or any tangible or intangible assets of the service provider. For example, if we see in case of doctors, whenever we go to any doctor, our main purpose is to get our diseases treated on the basis of skills and knowledge of the doctor. Now, during the course of that transaction, if he provides a certain medicines, or say he gives a particular injection to us, then it will not be treated as a sale of injection or sale of medicine in that injection from doctor to patient, because the main intention of the parties is to enter into a contract for services, is to get the services. So in order to determine whether a particular transaction is a transaction for sale of goods or a transaction for supply of services or provision of services, the first point which needs to be looked into is the intention of parties to enter into contract. As all of us know, that right from the very beginning, that is when the service tax law was there, which was under the powers of central government, and the sales tax law was there, where the state government was implementing the law. This issue, whether a particular contract is a contract for sale of goods or a contract for supply of services, has always been a matter of dispute or litigation. And whenever this type of transaction or the fate or the nature of this type of transaction was decided by the court, the first and the foremost test that was applied by the courts was what is the main intention of the parties to the contract. Whether the main intention is to transfer the ownership in the resources or in the assets which are involved into that contract, or whether the main intention is to get the services. Now, coming to the current dispute regarding assignment of leasehold rights by the lessee or by the allottee to a third party. Now, with the introduction of GST regime, we know that as far as immovable properties are concerned, transfer of ownership in immovable property, that is land and building, has been kept out of the GST net by way of insertion of an entry in Schedule 3 to the CGST Act. So basically these transactions are not exempted. They are not zero rated, but they are totally outside the GST net. Though for the purpose of ITC the treatment may be different, but currently we will not focus on that. So the transactions where there is a complete transfer of title in immovable property, they are outside the GST net. Only transfer of title in movable property or in goods is liable to GST. So in case of this assignment of leasehold right, there may be two type of transactions involved. Assignment of leasehold right in a land which is meant for industrial or business purpose, and transfer of leasehold right in a land which is meant to be used for residential purposes. Today we will focus only on the transfer of leasehold rights in a land which is meant for industrial or business purpose. So as I initially discussed, that in case of a contract for services, the purpose is never to transfer the complete ownership. If you see this transaction of assignment of leasehold right in a land which is meant for business purpose or industrial purpose, these type of lands are generally owned by the government, maybe central government, state government, and those lands are reserved for that purpose only, that is for industrial purpose. The object of the government is to ensure the industrial development of that particular region and to make sure that the land is easily available for the entrepreneurs. So let us take the example of any state government. For example, in case of Maharashtra, the state government has appointed a nodal agency for industrial development. One of the industrial agencies, Maharashtra Industrial Development Corporation. Similarly, in case of Gujarat, it is Gujarat Industrial Development Corporation. So the state government acquires the land for these industrial purposes. Then it appoints a nodal agency like MIDC in case of Maharashtra. And that MIDC has been given the various rights by the state government, and one of those rights is to give such land on long-term lease basis to those persons who are interested in industry or developing an industry or starting an industry. So the lease transaction, the long-term lease transaction, particularly long-term lease means a lease which is for the period of 30 years or more, or it may be for a lesser period. First of all, these lease transactions are liable to GST. Why am I saying this? Because if you see the notification number 12 of 2017, central tax rate notification, by way of entry number 41, the amount which is collected by these industrial corporations by way of a premium or a one-time amount or salami, whatever it is, that amount, or in other words, that particular type of service of long-term lease has been exempted from GST. And there are certain conditions subject to which this exemption has been given. So when a particular thing is exempted in a notification number 12 of 2017, at the first point of time, it means that it is liable to tax. It is liable to GST. That's why it was exempted. So as per the scheme of the GST law, this long-term lease transaction is liable to GST, irrespective of purpose for which it is given, irrespective of the agency or the person who is transferring such long-term, who is giving such land for long-term lease on long-term lease basis. So what is exempted? Long-term lease of land by MIDC or by any industrial development corporation which is an undertaking or which is owned by central government, state government or union territory, or in which at least 20% of the stake is owned by central government, state government or union territory. Now this 20% stake may be held by those government either directly or through another company or undertaking which is fully owned subsidiary of such government. So this is understood. Now which are the another conditions? The conditions are that the purpose for which the land has been given on long-term lease basis, the purpose can only be two. Number one, industrial purpose, and number two, development of a financial business. So financial activities, fintech industry for example. So if the land has been allotted for these two purposes, it must be used for these purposes only. And this condition is applicable not only to the first person to whom the land is allotted, this condition is applicable to all the subsequent holder of that particular land. For example, the Industrial Development Corporation has allotted the land to Mr. A. Mr. A has transferred the leasehold rights in that land to B. B has transferred to C. C has transferred to D, so on and so forth, to all those persons. Right from the original lessor, that is Industrial Development Corporation, up to the end of the transaction, all the persons are jointly and severally liable to ensure that the land has been used for that purpose only for which the originally the long-term lease was given. So this is condition number one. And if this condition is violated at any point of time, then right from Industrial Development Corporation up to the current owner or current person who is holding that land, they will be jointly and severally liable to make the payment of GST, which was originally exempted, along with the interest and penalty. Why penalty? Because the condition subject to which the exemption was given, that has been violated. Whether it was violated immediately after the long-term lease transaction or whether it is violated after 50 years. Penalty will be applicable, interest will be applicable for those 50 years. So this was about long-term lease transaction, first transaction. Where the land was given on long-term lease from an Industrial Development Corporation or government to any allottee. This is number one. So this is liable to GST. It is exempted only by way of notification subject to conditions which I have just discussed. Now coming to another part of this transaction, second leg of this transaction. For example, Mr. A has obtained a land on long-term lease basis from an Industrial Development Corporation. Now Mr. A, after some time or after some years, he came to know that he cannot use that land for the purpose for which it was allotted by the Development Corporation. Number one. Or because he is discontinuing his business, or he is intending to enter into an activity for which that land cannot be used. Number two. Number three, if the land which is allotted to Mr. A, for example, let us take the example that 50,000 square feet land was allotted, but now subsequently Mr. A came to know that he can use only 30,000 square feet. 20,000 square feet cannot be used by him. It is an excess land which is allotted to him. So what is the option available to A in all these cases? A can transfer or A can assign that leasehold right which he is having, which he has obtained from Industrial Development Corporation, to Mr. B. If he is discontinuing his business, Mr. A, then he can transfer the complete 50,000 square feet land, or if he is having some excess land, as I discussed 20,000 square feet, he can transfer that 20,000 square feet land to Mr. B. Now this transfer of land from Mr. A to Mr. B will not be a sale of land, because this is a settled position of law that a person can transfer only that thing which he himself is having. Since Mr. A is not the legal owner of the land, he cannot give the ownership to Mr. B. Who is A? He is a leaseholder. He is holding the land as a lessee on a long-term lease basis. Then who is the owner of the land? Whether Industrial Development Corporation is the owner of the land? No. The state government is the owner of the land. So the transaction is assignment of leasehold right, long-term leasehold right by Mr. A to Mr. B. Now whether this transaction is liable to GST or not. So this transaction has been a subject of litigation since last many years, especially from the time the GST has been introduced. And as we have seen that recently the Gujarat High Court, in case of Suyog Dicam, there are various other parties, has given a decision, a ruling, that this type of transaction is not liable to GST because it should be treated as a transaction which is similar to sale of land. It is on the same ground, or it should be treated as similar to sale of land or akin to sale of land. And since sale of land and building is out of the net of GST, this transaction should also be kept out of the net of GST. Now what is the logic? As you know, yesterday or 2 days back only, Bombay High Court has also remanded back a case asking the authority to make a fresh adjudication of the case on the lines of the judgment which is given by the Honorable Gujarat High Court in this particular transaction. So what is the logic? The logic is that in case of assignment of leasehold right in a long-term lease, when the leasehold right are transferred, what is the purpose of the transaction? What is the purpose of the transaction, Mr. A and Mr. B? The purpose is, the intent is to get the complete rights from Mr. A, or to transfer the complete rights of the land from Mr. A to Mr. B. And this is only a one-time exercise. The moment this type of agreement will be entered into, the A will be, all the rights of A in that land will be totally taken away. He will relinquish all those rights to Mr. B. So is it a service? Not at all, because the purpose is to completely get the rights in one time, and this type of transfer of right is not reversible. In this transaction, Mr. A is not only transferring the right to use, but he is transferring the complete title, or complete title means not the ownership. Whatever rights he is having in that land, he is transferring to Mr. B. So this is the transaction. And this type of transfer of right, relinquishment of rights of Mr. A in the land is irreversible. This is very important point, that the intention of the party is not to get complete transfer of rights, whatever rights transfer is having, and this is an irreversible transaction. And that's why the logic is that this type of transaction should be treated on the same grounds as in case of sale of land. Though I accept, or everybody accepts, that in case of sale of land, the ownership is transferred. Correct? But in this transaction, there is no ownership, because A himself is not having an ownership, but he is transferring all the rights. So in this particular principles, number one, intention of the parties, and number two, irreversible nature of transaction, and number three, complete transfer of rights. That's why assignment of leasehold right in case of such long-term lease should be treated as a sale of land, and it should be outside the net of GST. So as on date, till the date, we are having decisions from two high courts under GST era, that is number one Gujarat High Court and number two Bombay High Court. Now let us see how this particular litigation goes ahead. Till the date, this is the logic, and I think this particular type of logic and the reasons, they are quite reasonable, and this type of concession or this type of principle must be upheld even by the Honorable Supreme Court. Thanks a lot for the hearing. Thank you.